Hello, everyone. Good evening. Hello, hello, hello. My name is Ifeoma Odunlami, immigration attorney from the Odunlami law firm. I just want to say hello to everyone, and I have a great topic for you guys today. So I'm gonna wait for a couple more people to join me, and then we can hash it out. So when you join me, please say hello. Let me know you are here. It's always fun to see people. And hi, Banir Senior. Hey, T Jokonlomo, how are you? So, hi, Damilola, how are you? Happy Monday to everyone. Sexy Caddy, yay, Caddy, how are you? Thank you, thank you, thank you. So, guys, I have a great topic for you guys. And, I always think of these topics when, from my consultations. I think of something that may be useful information for all of you, or maybe I hear something that I feel I need to make sure that we correct a perception. Thank you from Turkey. Florence, thank you so much. I love you all too. So, um, Alaji, nice to see you. So, guys, this is a thing, right? I want to talk about I-751, and I want to tell you what that is and what I have been seeing and what I want you guys to know, right? So for those who are just meeting me for the first time, my name is Ifeoma Odunlami. I'm an immigration attorney from the Odunlami law firm. I'm not only an immigration lawyer, I'm also an immigrant, as you can hear from my accent. And in my office, I was just thinking about it. Everybody in my office is bilingual. We speak English and then we speak another language because we're all immigrants. So, hi, Michael, how are you? So let me tell you what the I-751 is, and I want to hone down on certain misconceptions that's floating around there. If you're married to a US citizen, a green card holder, and your marriage is less than 2 years at the time you get your green card, you will get a 2-year green card. And what that means is when you get that 2-year green card, you have to remove the conditions on the second anniversary. And typically you do this within 90 days of the second anniversary of your green card, right? So you look at your green card, it'll tell you when it expires. Within 90 days of the expiration date, you want to remove the conditions, right? So it's a temporary green card, right? And a lot of people, one mistake they make, which I want to make sure you guys are not making that mistake, is they file the form I-90 to renew the green card. And that's not what you should be doing. You should be filing the form I-751 to remove the conditions so that you can get a 10-year green card, right? So, but this is a problem. When people get their 2-year green card, they think they're over the hump. They think, now I have my temporary green card, I just need to remove my conditions and I get my 10-year green card and I'm there. But honestly, I want you guys to know this. I have found that the I-751, getting your permanent green card, many times can be even more difficult and more challenging to get than the 2-year green card. And you know the reason why? Because USCIS, this is one chance that they have to make sure that they made the right decision when they gave you the temporary green card. And what I've seen this with several cases where USCIS doesn't make a decision on the green card, right? When you file an immediate relative petition, but once it's getting to the second anniversary, they quickly give you that 2-year green card, because if they give it to you after your marriage after it's been over 2 years, then it's a 10-year green card. So they want another shot at looking at your case again to make sure that they made the right decision. So what I want you guys to know is, even though you have a 2-year green card, the obligations of making sure that you have all the information that you need and all the evidence that you need to remove the conditions to get your green card is still there, right? So let's talk about some of the reasons why people are not getting their 10-year green card. Number one, let me tell you this one because this has to do with many consultations I've had. when people have been denied and then they come to our office because they're like, why was my I-751 denied? And then we review the case and we tell them, this is why. Let me tell you one. So it's this fake divorces or these divorces that are not properly done in your country. So the first time you do it, you file the I-130, you and your American spouse or your green card holder spouse. USCIS either didn't pay attention to it for some reason, and so you got a green card, a temporary green card. And then it's time to remove the conditions. You and your spouse, or maybe you're removing it on a waiver, and then they begin to look at that divorce decree again. And they're like, we gave you a green card, but we think you got it wrongfully because we looked at your prior divorce decree before you married the US citizen or the green card holder, and we're now looking at it and we don't believe it's a properly executed divorce decree. Therefore, your marriage to that US citizen holder is void. Therefore, you shouldn't have gotten this green card. Therefore, we're denying your 10-year green card. Therefore, you have no status as a green card holder. So another thing I've found out is sometimes some people are married, their exes are in the United States, right? And then maybe one ex used that same divorce decree and got their green card, maybe even got their 10-year green card. But USCIS is questioning, maybe even became a citizen, but USCIS is questioning the same divorce decree. It happens. It happens. So just because your ex submitted a divorce decree and it was approved by USCIS and they were able to get their papers, does not mean that USCIS does not have the right to review your documents again and deny you or ask you to authenticate that divorce decree. So I've said this so many times, guys. There's some countries that their legal documents, USCIS has no respect for it, zero respect. If you're from one of those countries, do yourself a solid. If you are divorced in one of those countries, authenticate that divorce. Make sure it's a real divorce. Make sure that the attorney you hired got that divorce properly done, right? Before you marry the US citizen or you marry the green card holder. All right? You got to do it, because if you don't, your marriage to that US citizen or green card holder can be null and void, and it will render you no benefits. And it is so frustrating. Let me tell you why it's especially frustrating, because if USCIS feels that you've submitted a fake document, now it's that's fraud. And that can make you inadmissible. Inadmissible. So if you've been divorced before you get married again, don't rely on the fact that your ex used that divorce decree and USCIS accepted it. Please go and verify it. Even if you were not the one that, you were not the petitioner in the divorce decree, but just the defendant, that's still not an excuse. You're not going to say, well, I didn't know, I just got the divorce decree. I have never seen USCIS by that excuse. So you have the responsibility to make sure that your legal papers were properly done before you get into another legal agreement, okay? So that's one. Now, another thing that we find is a reason why people are getting denied their removal of conditions is they get married to a US citizen, they get their temporary green card, and then the next day they file a divorce. Or maybe they even filed a divorce before the green card, but didn't tell USCIS that they were divorced, and the green card came in the mail and they picked it up and kept on moving on with their lives. And guess what? Now it's time to remove the conditions, and USCIS is doing the math like, wait. We gave you the green card in April 30th, 2023, but your divorce decree says January 2023. That math is not mathing. And so you're going to have to explain why you didn't let USCIS know you were divorced or you were not together anymore, and you got a green card. Because as they give you that green card, they can take it. Even the permanent green card. You get a temporary green card, they can take it back. You get a permanent green card, they can take it back. So you're not over the hump until you become a US citizen. Of course, they can begin proceedings to denaturalize, but they rarely do that. So I think I'm kind of confident in saying, until you become a US citizen, you're not on solid ground. Typically, they denaturalize only people who they found have terroristic ties or were part of the Nazi or something like that. Okay. So if your relationship is not working out anymore, you're not with your spouse anymore, it's really not the best thing to get your green card and not tell USCIS about it. If you get divorced before you get your green card, you need to update them. All right. So that's one other reason why your I-751 could be denied. And so moving to the third reason your I-751 could be denied would be lack of evidence. So you gave them a whole bunch of evidence when you applied for the I-130, the first time. And then when it's time to remove the conditions, you have nothing. You submit the same thing you submitted the first time. Nope, that's not going to work. It's not going to work. They need to know that you continue to be in marital union. Because if you're not in marital union, then you have to use a waiver. And there are 4 waivers. We've talked about that before. There's a waiver of abuse. Maybe you are in an abusive relationship, or it's either emotionally abusive or physically abusive, or you had a divorce, in which case you are not together anymore, or extreme hardship, or the death of the petitioner at that point, right? So if you're not using a waiver, then you need to come correct with evidence to show that you and your spouse continue to live in marital union, and both of you are able to jointly remove the conditions. And let me give you this. Let me give you this tip. Sometimes you and your spouse are not living in marital union, but your spouse still wants to help you jointly remove the conditions. They can do that. They can say, it was a real marriage when we entered into it. It just didn't work out, but I'm still supporting my spouse to get, I'm still jointly supporting my spouse to get their 10-year green card. So remember this, proving a bona fide marriage is key. Don't be lax on that. Proving that your marriage was not a sham marriage, was not a fraudulent marriage, is top priority in a marriage-based green card petition, right? And so you guys know what to do. You know how it worked. You have to show USCIS loves financial commingling. So if you have evidence of financial commingling, please submit it. And if you don't, it doesn't mean that you're not going to get what you're looking for, but it just means that you have to have other solid evidence, right? If you have a child together, bring the birth certificate, you bought a home together, you're renting together, you're flying on vacations together, good stuff like that, right? So another reason why your I-751 could be denied is you filed too early. You're supposed to file within 90 days of the expiration of the 2-year green card. Don't file too early, don't file too late, because if you file late, they could already have NTA'd you, which is served you with a notice to appear, which puts you in immigration court, deportation proceedings, all right? Another reason your I-751 could be denied is criminal activity. If you commit a crime, aggravated felony, CIMT, which is crimes involving moral turpitude, that could put you at a danger of losing your temporary green card or even permanent green card, right? And they call you for an interview for the I-751, you don't show up, they're going to deny it, right? And USCIS believes your marriage is fraudulent, they're going to deny it. And so just like I said, just because you have a green card, a temporary green card, does not mean that they're going to not scrutinize your case again. No, they get a chance to do it again. And they get a chance to do it if they wish again when you're filing for naturalization. So if you have to remove the conditions on your green card, please take it seriously, really seriously, all right? And if you don't use an attorney, make sure you're doing your homework. If you need assistance with removing your conditions, my office does a lot of those. And our number is 973-993-1900. So I'm going to answer some questions, and then I'll head out because I have to pick up my son from the bus. So let's go to Tamika Green. Tamika Green says, hi, my case is 2 years and 7 months now. My lawyer just updated my green card. In 5 days, I received the I-797C. You think they soon approve my I-360? And how long you think my green card will come? Tamika, if I knew that, I would be magical. Nobody knows how long USCIS is going to take to approve your I-360. It varies. If you look at the case processing times, it's taking them anywhere from, I think, 3 to 3.5 years. And that's 80% of it. So the other 20% could come earlier or it could come later. So I can't really tell you, but I wish you the best though. Okay. Unfortunately, VAWA cases are taking so long. U visa cases are taking even longer. But you know, USCIS increased their filing fees April 1st, and they've promised us they're going to become more efficient. So let's have hope, okay? So BT says, if someone is seeking asylum and got charges, what are their chances? So BT, I don't know what the charges are. They're charges, and then there are charges. So we need to know what the charges are, okay? And yes, Tamika, you've done your biometrics. This is your VAWA. You just have to wait. You know, you've done your biometrics. They'll keep giving you a prima facie every 6 months. Sometimes they even forget to give it to you, and you have to reach out to them and remind them. But it's a waiting game. It doesn't mean that anything's going wrong with your case. You just have to wait, okay? So hang in there, all right? All right, let's see. Let me go to Instagram and see what's good out there. So I have people from Antigua. Hi, Jana Million. Hello. Let's see. I'm looking for a couple questions from Instagram. Thank you for the compliments. So AK1 with God says, have married twice and filed twice. What's the implications? AK, I mean, honestly, just because you got married twice and had a petition filed for you twice, it doesn't mean that you're not going to get your case approved, right? But USCIS is going to probably just, second glance to make sure that both marriages were bona fide, right? And so your job is to make sure that you're producing evidence that each marriage was a real marriage. Every time you're married to somebody and they're filing for you, get your evidence, people, okay? Get your evidence. And if you get your evidence, there's no punishment because you got married and somebody filed for you twice. It's just that you have to show that each marriage was real. All right. Let's see. So, Blessed by the Best Car Wash says that, hey, I passed the question, but I didn't pass my reading. I'm thinking you meant naturalization. Blessed by the Best Car Wash. I'm sorry to hear that, but you can try again, and I wish you the best, okay? So, Josh says, I'm sorry my question is not on today's topic. That's okay. You can ask questions on any topic. So he said, if I have my EAD and travel parole waiting for my green card, can I travel outside the US? So, that's a loaded question. And I tell you, the reason why it is even though your travel parole allows you to travel outside the United States, it's not an automatic, like you could still do stuff that disqualifies you from being able to come back. For instance, if you committed a crime and you left and they may not let you back in, or the CBP officer gets extra frisky, goes through secondary inspection, and and they find something that raises an alarm, they would not let you back in. So I think the best thing to do is, which is what I tell my clients, when you want to travel, call us and let's talk, and basically ask some questions to, kind of have a sense of, how it is going to be for you. But we don't have control over CBP. So a lot of my clients, they've in fact, every client I've had has gone and come back safely, but it's not automatic. Don't assume that just because you have an AP that they're going to pull out the red carpet and say, oh, come on in. No, that's not how it works. Okay. So I hope that answered your question. Oh, yay, Josh. Let's see. So Fresh says, how long does it take to have an I-601 waiver approved? It really depends. I think the best thing for you to do is just go to the case processing site and put in your information. I mean, we've gotten I-601s approved really quickly, and we had some that waited for 2 years before it was approved. Honestly, it's hard to tell. So Jumi for Dikpo says this, and this is really important. I want to answer this question. She says, please, Ma, can I still file asylum with my kids after 7 years in the United States? So Jumi, you must be aware that there's a law that says that you must file your asylum petition within 1 year of coming into the United States, right? Now, the rule is different for your kids, right? So the thing is this, that's the rule. Now, if there's an exception where there's something happening that wasn't there before that has now occurred, and therefore you cannot go home to your country and you're going to be persecuted because of something that recently happened, it has to be extraordinary because the rule is the rule. So when I see people filing asylum and they've been in this country for over a year, that is a straight pathway to immigration court to deportation proceedings. I'm going to tell you that. It's a straight pathway. So don't let any notario or any lawyer get you to file asylum when you've been in the country for more than 1 year, unless there is an extraordinary reason that you didn't file. Okay, so for us to know whether there's an extraordinary reason, we would have to talk to you. But honestly, nobody who's come to my firm has had an extraordinary reason for filing asylum after 1 year. So be careful. All right, it's 5:57, guys. I'm going to ask one more question, and I gotta go. So Michael Tete asked a really important question about T visas. Please, how does USCIS investigate T visa cases? Do they contact the trafficker? So Michael, when you file the T visa, you're required to file a report with the law enforcement agent, right? Whether they contact the trafficker really depends on them. A lot of times they don't, if it's domestic trafficking or something that is not of a caliber that they want to put their resources in it. But now, if it's a case where it's a sex trafficking of young people, or it's a place where they're, like an employer who's trafficking in mass a lot of people, they may want to investigate it. But what I need to tell you is that they don't investigate every case. They don't, and that's the LEA, the FBI. They don't, and you should talk to your lawyer about what your situation is and what the likelihood is that they would actually contact the trafficker. A lot of times, T visa cases, like VAWA cases, like U visa cases, there's a lot of, they know that victims can be traumatized. So they really have to be careful with making sure that they don't put the victim in danger, okay? So that would be that. So guys, it was a pleasure talking to you guys, but I gotta run because it's 5:58. I need to go pick up my son, but I'm gonna try and come back again with another great topic. And I hope you guys found value in this topic that I presented today. And of course, if you need immigration assistance, we do family-based, we do humanitarian, call my office, 973-993-1900. Take care.